Campbell. Mr. Campbell, good morning.
Good morning, Your Honors. May it please the Court. My name is Brandon Campbell, and I represent John Doe, the petitioner in this case. The legislature has recognized the value of expert testimony by making it specifically admissible under the enabling legislation for the SORB. The SORB has recognized the value of expert testimony by making it admissible under their regulations. In fact, the SORB has a pre-hearing order which is applicable to all cases that permits a long list of psychological tests and sex offender risk assessment tools to be admitted at the hearing. Yet, Doe and petitioners like him, because they are indigent, are being systematically deprived of the opportunity to present this very important and persuasive type of evidence. Evidence which, I might add, can only help the hearing examiner make a decision, make a more accurate decision, which, of course, serves both petitioners and the public equally. Now, the board has admitted in their brief that they never use experts. So under the statute, indigent petitioners never qualify for funds for an expert. There's a principle in the Supreme Court case of Akey that I want to point out, because the board seems to think that it's fair. If they don't use expert evidence, then it's fair not to let indigent petitioners use it. And in Akey, which was a criminal case and related to indigent people getting funds for psychologists in criminal cases, the court said that mere access is not enough to ensure that someone receives, that the adversarial process functions properly. The way the adversarial process functions properly is that a party is entitled to put together their best case and submit it for a decision irrespective of what the other side does.
Was that a Sixth Amendment case?
I believe that was.
This is not a Sixth Amendment case.
This is not a Sixth Amendment case, and certainly there are important differences between criminal cases and SORB and SDP cases and SORB cases. But I submit that, this court said in Doe 3 that a petitioner is entitled to an individualized hearing based on the liberty and privacy interests that are involved.
Mr. Campbell, if John Doe was not indigent and if he could afford to hire an expert, would he be allowed to?
Yes, he would, Your Honor. In fact, that there doesn't appear...
Even if the board did not rely on an expert?
That is absolutely correct. And any attorney who represents petitioners in this area, if they're worth their weight in salt, the first thing they do is they tell their client to go out and get an expert, multiple experts. You can, if you want a real-life example, there's an affidavit from attorney Kathy Hinton that's in the record, which shows that it's been used many times in her cases to great effect.
And you've included the decision of Judge Ball, I think, which had a number of experts.
Yes, we did. Yes, we did, Your Honor. The current system, it's not fair, it's not reasonable, and it's not rational to let one class of petitioners, those with money, to come in and present all of the expert evidence that they want, yet deny indigent petitioners the right to present any expert evidence, even a written report. For the adversary system to function properly and for these classifications to mean something, there's not supposed to be a separate classification system for rich and a separate classification system for poor. 1, 2, 3 is supposed to be the same for everybody, and that's not what's happening here. And I want to talk a little bit about accuracy. 803 CMR 1.40, that's the regulation that the board uses.
You have to go a little slower for me.
I'm sorry.
803.
1.40.
Okay.
That is the classification regulation that the board uses to make its determinations. It's got the list of all the factors in it. if you look at these factors, they rely heavily on scientific studies.
Well, the board, as you know, says it's only factor 2 and 10, or, I mean, I can't remember what the board said.
2 and 24 factors relate to mental health, I guess.
Correct. It's interesting that I think in many ways a SORB classification is more complicated than in an SDP context. Because in an SDP case, the only real question is whether or not there's a mental abnormality. In these cases, there's many more factors than that. And you can see that by all the studies that are cited in the regulations. They go way beyond whether or not there's a mental abnormality.
Did Doe have access to any medical reports of his own doctors that might have helped in terms of expert opinion? He was bipolar, was he not?
Yes, he was.
Of the manic type, whatever that means. I take it you act out more than you get depressed. But so obviously he'd been diagnosed by a doctor to have this, correct?
Correct.
Did he have those medical reports?
Well, the diagnosis of bipolar that appeared in this case actually came through a criminal responsibility evaluation that the board introduced. So that's how it
That
came
may
in.
be, but do you know, or did trial counsel or whoever represented this man have access to other physicians' reports apart from that in the treatment of this man? I mean, obviously, he was diagnosed by probably by a doctor other than the criminal responsibility report. Given medication, wasn't he taking medication of some sort?
Yes, I'm certain that the petitioner would have had access to his own medical records, but it really wasn't.
Well, wouldn't wouldn't he have a duty or burden, shall I say, in the first instance to produce those reports?
The burden is on the board, and where a petitioner.
Well, no, the burden's on him if he's asking for funds for an expert witness. We're talking two different burdens here, it seems to me. When the board is faced, and the hearing examiner with a regulation or statute, whatever it is, that says no expert, the burden's on him to show that he should have one. And it seems to me his own medical reports might help with that, and he didn't even bother bringing them in.
I disagree, Your Honor, because what he needed was a sex offender risk assessment, not just diagnoses from a doctor that he had bipolar. He needed to be able to put in the evidence concerning that, what the effect of bipolar is, if any, on his risk of reoffense. What is the effect of therapy, medication? Some medications.
But we don't know if his own doctors might not be able to give some sort of opinion on that, do we? I mean, if he's seen a psychiatrist or someone who's a professional in the mental health area, they probably have some acquaintance between the nexus between bipolar disorder of his type and possible sex offense.
It's not been my experience, Your Honor, that doctors are willing to give sex offender risk assessments for free.
But
in this type of
doesn't
case.
that go to the nub of the case? That
You don't even look at the records.
That you need his doctor or some doctor to come in and write a report or testify, correct? You can't have reports that diagnose him that may say nothing about risk of reoffense of sex offenses.
Exactly,
And
Your Honor.
admit those.
It's not helpful just to put in evidence that he has bipolar. It's what you do with it, the connections you make with that.
And it could be his own doctor, but your point is that doctor has to be paid.
Correct.
Not that doctor wouldn't be helpful.
Oh, I don't know about that.
But-
You can get your own medical records for free or for a nominal sum.
But the medical records wouldn't deal with that issue.
Correct.
We don't
And this is
know.
not a hurdle that people who are indigent or not indigent have to deal with. They can go directly to a psychologist or a psychiatrist who has specific experience in sex offender risk assessment and have an evaluation.
But his lawyer, he had a lawyer, right?
Correct, and I was that lawyer.
Yeah. You could have gone and said, give me the names of your doctor or doctors, mental health professionals, and you could have contacted them and say, I want his reports. Correct?
Correct, Your Honor. And I failed to see how that would help the hearing examiner make a
How do we know? We haven't
classification
seen, we haven't
determination.
seen the reports. You haven't seen them, have you?
I have not, Your Honor.
Can I ask you this? Do you know, and maybe this is a privileged communication, but do you know whether or not he was treated for bipolar disease, or was he treated for sexual fantasies and acting out sexual fantasies or sexual behavior, whatever form it took?
There was evidence that we submitted that Doe was he was being treated by the Department of Mental Health. He was going to a day program where he was being supervised. He was also being treated by a psychologist. His medications were being reviewed. There was evidence that there were regular blood tests being taken to ensure that he didn't have any toxicity, and also that he was complying.
Were any of those records obtained?
They were offered in evidence, right?
Yeah, we have letters from I believe from the treatment providers, but they're very nonspecific. And frankly, I went to the place where he's currently receiving services, and I specifically asked if they would be willing to give him some kind of recommendation as to risk, and frankly, they just didn't want to be involved in that. They were willing to go so far and say that he was going there, and he was going there every day, and they were watching him, but they didn't want any part of any sex offender registry proceeding.
Was he ever hospitalized, whether you know?
According to the criminal responsibility evaluation, he was hospitalized in the early 90s.
Can you tell me about the cost of an expert in a typical case? How would it work? The indigent, if we agreed with you, the indigent would apply for an expert, and the judge would say, I approve up to $1,000, or set a dollar figure. And in a typical case, what might that be?
In my experience, for an expert to write a report and to testify, it would be between $2,000 and $3,000. Now, the board...
Can I go back to the early 90s again? He was hospitalized. Do you know where he was hospitalized?
I believe it was McLean Hospital.
Okay.
But to get back to your Honor's cost question...
Let me ask you one more thing. That's a relevant time period, isn't it? Because the 1991 incidents play a big, or incidents, plural, play a big part in this. So wouldn't somebody want to have looked, did anyone look at those McLean records?
Those records were not introduced into evidence.
Were they looked at?
No, Your Honor, and
And the 1991 incidents would have been around that time, would they not?
I fail to see how it would be helpful in trying to prove that this petitioner is at a lower risk,
Well, you can't
all
tell
kinds
him.
of psychological
You can't tell
records
until you look at the records.
without any expert testimony about the effects of that on the risk of reoffense
At the present time.
at the present time. Now, to go back to your question, Justice Ireland, the board makes a big deal about cost in their brief, and I would suggest that the fundamental question about cost first is the cost of misclassification, both for the patients, petitioners and the public. But with respect to cost, I would point the court to the amicus brief that was recently filed. It was filed on Friday. They've got some very interesting statistics in there about how many petitioners actually request hearings. Now, according to a public records request that the board responded to, only 1 in 3 petitioners request a hearing. And of those 1 in 3, only about half of those petitioners are indigent. So from the year 2007, I believe that was about 360 hearings that we're talking about. We're talking about 15% of cases. Now, I'm not saying that every indigent petitioner willy-nilly should be entitled to all the funds they want, and that's why I've suggested that this court follow the standard in Chapter 261 and outlined in the Lockley case, that it only be allowed in cases where it's reasonably necessary to prevent a disadvantage as opposed to somebody that can afford to pay. There's another statistics in the amicus brief that I want to point out that's very interesting, and it shows that in 2007, 44% of indigent petitioners received a level 3 rating, whereas only 23% of non-indigent petitioners received a level 3 rating. So twice as many indigent petitioners received the highest rating. By the same token, if you look at level 1 petitioners, only 12% of indigents were classified as level 1. 26% of non-indigents were classified as level 1. So there's about twice as many level 1, lowest level, non-indigent petitioners. This is no accident, Your Honors.
You would say, I take it, you have to say, that this liberty interest here, albeit limited, is broad enough to, because you have to get to the Constitution in order to get to your argument, don't you? I mean, because clearly this doesn't exist by statute.
Absolutely, Your Honor. It's absolutely a constitutional question. And as I said, there's significant differences between criminal cases and SDP cases, but there's very serious interests here, especially in a case like this where, quite frankly, this registration is probably worse than any of the criminal sanctions that he received on any of his cases, because he could potentially have to register for the rest of his life, as opposed to a few stints on probation. This is worse.
Thank you, Mr. Campbell.
Thank you, Your Honor.
Mr. Burke?
Thank you, Your Honor. William Burke, representing the Appellee Sex Offender Registry Board. Your Honors, it's the Board's position that the Superior Court in this case properly determined that the plaintiff in this case was not entitled to funds for an expert at his 178L hearing and under Chapter 261 while pursuing his 30A Section 14 complaint for judicial review.
He agreed, more or less, didn't he, that he was at least a level 1? Did he not?
Correct. At the hearing, he asked for relief or, in the alternative, a level 1.
Okay.
Mr. Burke, what do you do, though, about, there isn't a statutory right, but what about the fact that the hearing examiner specifically uses as part of the rationale that this is somebody that's got bipolar disease, and under DSM-4, bipolar means X, Y, and Z, and so therefore that adds to my finding that it's part of what I'm factoring in reaching the level that I reach. I mean, that's really an expert judgment, isn't it?
No, it's not, Your Honor. I think, first, the issue of bipolar disorder was not objected to at the beginning of the case. It was actually embraced by counsel in his opening statement. The testimony by the witness almost dealt exclusively with the bipolar disorder.
But it's not expert testimony.
Correct. It's not expert testimony. But the bipolar issue was already determined by another doctor in the past. To get to your question about the DSM-4, I think it's important to look at exactly what was said. The hearing examiner, that's under the record appendix at 108 and 109, the hearing examiner specifically said he's not citing this text to say that the plaintiff's going to reoffend criminally. He's saying that the record evidence in this case, as well as the factor analysis, make his bipolar disorder to exacerbate his already substantial risk in this case. And the record evidence does support that. The mother's testimony supports that. She indicated back in 1992 her son was on and off his medications. He was fooling her when he was taking his medications, and that's when he got in trouble. In 2003, if you look at the criminal responsibility evaluation form, the plaintiff admitted to Dr. Carroll, who did the evaluation, that he probably missed his dose of medication the day before the incident occurred in 2003.
I can't find the record right here, but I thought the hearing officer or hearing examiner made a specific reference to what DSM-4 says about potential for acting out violence, that kind of thing.
Correct. The hearing examiner cited the DSM-4, went through exactly what bipolar disorder is, because it came up during the hearing and was part of the record and wasn't objected to. But the hearing examiner went on to say that I'm not citing this text to say that he's going to reoffend criminally. He was just citing it to educate himself as to what exactly the elements of bipolar disorder are through the DSM-4.
Mr. Burke, do you think it's fair that indigents can't have expert witnesses and people who aren't indigent can?
I do, Your Honor. In these cases, I do. In Sex Offender Registry Board cases.
Can you explain that?
Sure. There's always going to be situations where offenders that can't pay for something are going to be treated different in these cases. Offenders who have money can get the best treatment money can buy. Does that mean that an offender who can't afford that deserves that and can bring that expert in or their therapist in to testify about their treatment. No, in these cases, the board and indigent offenders are on the same playing field. We have the 24 regulatory factors plus additional sub-factors if you count those in. And again, we're both on the same level playing field in this case.
Mr. Burke, can I just ask you, I assume that he is, Mr. Campbell is correct, that the board never uses experts?
The board has never used an expert.
I'm not asking it as a policy matter.
Sure.
Even in cases where there has been an expert by the petitioner?
Correct, Your Honor.
Okay, so and there's no reason why it should. It can just rely on the evidence that it has in front of it, correct?
Correct, yeah. The board has never called an expert in these cases, even in situations where
At first glance, that might seem strange, but it really isn't, because the board, by reason of all that's occurred, usually has a great amount of information on the sexual predilections, if I can use that word, of the offender. I mean, there have been court proceedings, there have been probation reports, there have been responsibility examinations, competency examinations, et cetera, et cetera, et cetera. So you got a lot of stuff.
Correct, Your Honor. And we try to get as much information as we can on the offender in his past.
And then for the examiners, you've got a grid, which creates these, whatever number it is, 24, 25, 30 measurement factors.
Correct.
Right.
The hearing examiner is guided by the regulatory factors found at 803 CMR 1.40. Correct.
How do you respond to Mr. Campbell's statistics that he referred to at the end, which seem to suggest that indigents wind up classified as level 3s more frequently and also apparently level 2s?
Well, I haven't seen those statistics. I haven't
You
seen
heard them, though.
I just heard them for now, and I would say that is a little inaccurate to say that indigent offenders are classified higher than offenders who are not indigent. I just think that's an inaccurate statement to say that. Again,
For him to prevail, we'd have to go to the Constitution, would we not?
correct.
And it is very doubtful that the United States Supreme Court would ever say, under the federal Constitution, that experts are required in these kinds of cases. So what are we left with? The state constitution? Is that argued?
I believe it is argued in this case, but I would say that, Your Honor, that the test in these cases would be the Matthews versus Eldridge test for due process. I believe that's what counsel is arguing.
Yes, that is argued, and frankly, I would be astounded if the Supreme Court of the United States handed down an opinion saying in all the state courts throughout the land, it's mandatory under the due process clause that you've got to pay for experts for sex offenders at
Correct.
classification, civil classification hearings.
But I don't disagree with Justice Crane, but there's also an equal protection argument here as well, not just a due process argument.
Correct.
Correct.
So what's other than cost to the state, is there any other rational basis from distinguishing what indigents can not do and what non-indigents can do?
Well, again, like you said, the cost issue is a big factor in this case. It's also
I can't think of any other reason. Is there any other reason?
the efficiency of the entire process in classifying these offenders. If you throw into the mix expert witnesses to come and test.
But you've got people who can afford it have the right to, I take it, put on as many experts as they want to.
Can you repeat that?
People who can afford it can bring on as many experts as they want to, providing that the hearing officer determines that the testimony or the reports are relevant, correct?
They can, Your Honor.
Yeah.
So it's difficult to make an efficiency argument based on somebody's inability to pay, isn't it?
Well, if we're assigning experts in these cases to all indigent offenders.
Not necessarily. Mr. Campbell is suggesting, the test that we've used in other contexts, that there has to be a determination by the hearing officer that it's reasonable or rational.
Correct. And I think if you look at the motion that was filed at the administrative hearing, it is extremely general. He just indicates that he needs the funds for an expert so we will have a fair hearing and to help advise counsel on the application of the regulatory factors. So
But
in this,
I'm sorry.
I was just going to say, in that general sense, every offender would be entitled to an expert in these cases.
But that's a separate question. In other words, if you say there may be some right, but it's not every case, and maybe this particular application doesn't meet the standard. But, those are two separate issues, though, it seems to me.
Yes, that is. There's two separate issues there.
I'm wondering when it might be an abuse of discretion to deny a defendant funds to hire an expert. What if the paperwork shows that the board has pretty strong evidence on 5 or 6 of these 24 factors, and the defendant himself shows that he has pretty strong evidence on 5 or 6 of these 24 factors? What kind of a showing does he have to make that he would like to hire an expert for those other 2, factors 2 and 24?
Under that circumstance, I don't think expert would be allowed in that case. I think in a case where the petitioner can show that his case is so unique and the condition he has, the hearing examiner is going to need this expert testimony to come up with the right determination in the case. Under that circumstance, I don't think that an expert would be allowed by the hearing examiner.
And is that because he has evidence on 5 or 6 of the other 24 factors?
Of course, and as you pointed out, Factor 1 and Factor 15 are the only 2 factors that deal with expert evidence. And Factor 1 is a high-risk factor, so if it is found in a case, it's an aggravating risk factor. So that leaves us with Factor 15, a psychological or psychiatric profile indicating a risk. So in these cases, if the board isn't offering that as saying that someone's a high-risk to reoffend through the expert testimony of someone who was retained just for the purpose of the classification hearing, he is in no way disadvantaged by not receiving expert funds in that specific case. And again, Your Honors, I think pointing out in this case dealing with expert evidence, and to point out something that was brought up, the plaintiff in this case did submit information regarding his bipolar disorder. He submitted letters from...
But my trouble with that, and you may be correct that an expert isn't required here, but my trouble with that is that not everybody who suffers from bipolar disease runs the risk of being a sexual offender. And it is not, I suppose that there may be sufficient in the record here to suggest that his particular manifestations of bipolar disease are, sex offenses. I assume that that's the board's position, correct?
Correct. When he acted out through his bipolar disorder, he acted out sexually. But I think it's important also to point out that the hearing examiner found that at the time of the hearing, he had his mental health issues under control and actually credited the plaintiff through the evidence and the testimony that he presented at the administrative hearing in this case.
So the risk here is the risk that he will not keep on his medication.
Well, he's demonstrated that in the past.
No. That's in other words, I took you to saying crediting. If I take that the evidence is that he stays on his medication, he doesn't, quote, act out sexually, unquote.
Correct.
So the risk is that he will not stay on his medications, correct?
Correct, Your Honor.
And then,
Is that the only risk? Is that the only risk?
no, because then if he doesn't stay on his medications, there's a risk that he will
There is a
act out
risk, potentially, yes, that he will act out sexually. It's not the only risk in this case. He's acted
Not
out.
the only evidence of risk, I assume.
Correct.
There's all those other standards, 24 different factors that were considered.
Correct. And again, that the substantial evidence portion of the argument supports that level, too. Repetitive and compulsive behavior.
Just so that I'm clear, is there any evidence in the record that he acted out sexually while he was taking his medications?
No, Your Honor. Not that I'm aware, because in 1991 and 92, when his first incident
You
occurred.
said his mother testified that she...
Correct. In
yeah.
03, he testified again that he wasn't taking his medications.
Right.
There's also additional evidence in the record to show that in the summer just prior to his 03 offense, he wasn't on his medications and he got himself in trouble.
Are those the police reports?
No. No, that was contained in the criminal responsibility
Do you want to
evaluation.
just address the police reports, whether or not they should have been admitted as reliable?
Correct. The hearing examiner in this case found that in 1991 the plaintiff was received a continuance without a finding for one count of open and gross and lascivious behavior. The hearing examiner found in his decision that it was useful information to prove that in the era of 1991 and 1992, the petitioner in this case exhibited poor judgment by an inability to maintain appropriate boundaries with children. So the hearing examiner in this case used that continuance without a finding just for that specific purpose. Plaintiff argues in his brief that the hearing examiner used that continuance without a finding to support aggravating factors, and that's just inaccurate in this case. He says factor 7 was used, the relationship as a stranger, while the 1992 victims were strangers. Factor 9C8, the duration of offending behavior. Is offending behavior almost a decade long? 9C4, public place. The offenses in 92 were public place. Factor 9C1, extra vulnerable victims. The 92 victims were extra vulnerable. So the factors that the hearing examiner relied on in this case were a result of his convictions, not the continuance out of finding
Okay.
in this case. If there are any other questions, I'll rest in the remainder of my brief.
Thank you, Mr. Burke.